Good evening. This is the May 20th, 2021 special meeting of the St. Mary's County Board of Appeals located in the Commissioners of St. Mary's County Meeting Room of the Chesapeake Building, 41770 Baldridge Street, Leonardtown, Maryland. I'm Chairman Dan Icniowski, and here with the other four members, and I'll have them introduce themselves.
Good evening. Rich Richardson.
John Brown.
And again, Dan Icniowski.
Wayne Medinsky. And
joining us on Zoom are also Lynn Delahaye, our member, and also
Hi, this is Lynn.
and also Guy Bradley. And they're both
Hi, everybody.
both here on Zoom with us. We have the board's attorney here tonight, Steve Scott, and then we also have the director sitting in the back, hiding, is Bill Hunt. Up front is Harry Knight, the Land Use and Growth Management Deputy Director. We have the County Attorney, Dave Weiskopf, with us tonight. Sherry Young, the Recording Secretary, and in the adjoining media control room is Amy Carter, who's a St. Mary's County video media producer. Again, tonight we have a special guest speaker and in the conference room here, and this is Emily Venneri, and she is the State of Maryland Assistant Attorney General assigned to the Critical Area Commission. And she's going to have a presentation for us, and we're looking forward to it. Talk about variances.
Okay. So thank you so much for having me. Again, I'm Emily Venneri. I think the third time is the charm, as they say. So the first time, we were talking in the car on the way here, the first time that we had set up this session, we were driving a state car and the lights didn't work. So we had to pull over. We couldn't make it all the way down here, and we had to get rescued by somebody else, by Annie, actually. Annie, who's here. Annie rescued us on our way down and brought us back to Annapolis. So that was the first time. I think the second time we had tried to arrange something, and it was right before the pandemic, and so this is the third time, and so we made it. The car survived, and we are all here. So we are really third time's a charm. So we're very thankful for having us here. Thank you very much. I'm just going to introduce Annie Sakarik, who's behind me. She's a natural resources planner, and then Kate Charbonneau with the Critical Area Commission. She's the executive director of the commission. A little bit of background about myself. I'm an Assistant Attorney General for the Critical Area Commission. I've been doing that for about 5 years. And before that, I was the Assistant Attorney General for the Maryland Department of the Environment. So overall, I've been with the AG's office about 12 years. When it comes to critical area issues, I obviously represent them in court whenever there are court cases, but I also help out a lot providing advice on regulations and policy issues, and then some of the day-to-day variance requests that that you all see, and the letters that you see, I sometimes have a little bit of a hand in. So I'm just going to dig right into my presentation, which I know you guys have. And first of all, of course, I have to give the caveat that this is just a presentation for information only. I'm not giving you any advice. I can't tell you any legal advice. That's what your lawyer is for. And at the same time, you know, this is not any opinion or advice of the Attorney General himself. Just me, just Emily. So, and then do I just say next slide to you, Harry? Okay, great, next slide, thank you. So this is the overview of what we're gonna talk about today, the statute's history and background, and then we're gonna get into the variances themselves and talk about how you get your jurisdiction, the presumption that is in the law, the burdens of proof and persuasion, and then get into each of the variance standards themselves. I really encourage questions, so feel free to stop me at any time. Otherwise, I'm just going to talk for, you know, until you tell me to stop. So I'm a good talker.
So you're going to be a typical lawyer.
I am going to be a typical lawyer. Yes, I'm going to talk because I like to hear myself talk. That's exactly right. So next slide, please. So let's start out with the history and background of the Critical Area Statute. Go ahead to the next slide. Thank you. The Critical Area Statute was enacted in 1984, and this resulted from the acknowledgement that the Bay was in a state of decline, and that state of decline was found by the EPA, performed a study of the Chesapeake Bay and determined that the decline was attributed to water quality and habitat destruction that was associated with land use and development activity. So it was directly tied to additional development, and that's what was harming the Bay. And so the General Assembly of Maryland realized that a new strategy was needed in order to restore and protect Maryland's water resources, and that's when they came up with the Critical Area Statute. And it's an interesting and unique and possibly the only one in the country, this unique partnership between the state Critical Area Commission and the local jurisdictions, and how the state standards are actually implemented at the local level, and they work cooperatively to administer and implement the local programs, while at the same time it can be customized to each local jurisdiction's needs and requirements for what it needs to implement its own program in its own unique areas. So in 1986, the criteria was adopted, and then the local governments were required to adopt their own local programs after that criteria was adopted. In 2002, the statute was amended to add the Atlantic coastal bays, and then there was a comprehensive revision in 2008 to the statute. There have definitely been some reg adoptions since 2008, and there have been some minor tweaks to the statute, but 2008 was really the last time that there was a fairly significant overhaul of the Critical Area Statute.
Can I interrupt you
Of
one
course.
second? You said in 2002, the statute amended to add Atlantic coastal bays to critical area.
Yes.
What was it before, and what are you talking about when you say coastal bays? Chesapeake Bay or Britton Bay? What are you talking about here?
So it's the whole name is the Critical Area Commission for the Atlantic and Chesapeake Coastal Bays. So there are Atlantic coastal bays and there are Chesapeake coastal bays. And so that's why, is it Worcester County? Worcester County is the only county that actually has both the Atlantic coastal bays and
You said
the
bays off the Atlantic as opposed to the
the
internal.
Chesapeake. Yep.
Okay.
Exactly. Yes.
Another
Great
question.
question. Yes.
In the 1984, used the word dramatic decline in water quality. When I first arrived here from Japan, I attended a lot of meetings about the Bay and specifically oysters, because I was involved in oysters and I'm a willing farmer. And they talked about the decline of the Bay.
Mm-hmm.
Well, I live on the Bay, and I was going fishing often. I didn't see a problem. I had asked some of the presentations if they knew anything about the Bay. All they had was the paper in front of them. Mm-hmm. They had no knowledge of what they were talking about. Mm-hmm. And I don't know there's a decline. I mean, everybody seems to think so, but the fish are still swimming and the oysters are still oystering.
Right. No, I think that's true. I think back in 1984, it was an EPA study that evaluated the Chesapeake Bay, and they had determined that there had been this dramatic decline. I mean, I think you're right. There are definitely still fish. There's definitely still oysters. Obviously, I don't have the statistics. The oyster production is 10% of what it used to be, 5% of what it used to be. So there are definitely some dramatic declines there. But I think what they were really looking at the time, I wasn't around. I mean, I was around, but not in this job at the time. So,
So we're shooting a messenger here.
yeah. So I think what they were really looking at was the water quality and that habitat destruction, right? So the destruction of the plants and the aquatic resources due to the increased development around the bay and around the shorelines.
Of course, you have to look at who was the sponsor of the study, the EPA. So
The EPA.
you would expect certain results because of that, too.
Okay, yeah. I mean, I think that's fair to say.
Just to share some personal knowledge, I used to crab when I was a kid, and the seaweed was everywhere. And I could crab up to my waist. You can't see nothing if you go in waist high now. And there isn't any seaweed. I mean, seaweed's, pretty much gone. It's starting to come back, but it's pretty much gone.
Thank you.
Yeah, you're welcome. So what is the critical area? The critical area is made up of all waters of the Chesapeake Bay, the Atlantic coastal bays, and their tributaries to the head of tide, and all of the land under the water. So that's one of the interesting things that I learned when I became the critical area commission lawyer, was that it is the water. The water is the critical area, as well as the land underneath it, all state and private wetlands, and then all land areas within 1,000 feet of the landward edge of tidal waters and tidal wetlands. So what that really creates is a swath 1,000 feet wide that goes around the Chesapeake Bay and its tributaries. Next slide. It affects 11% of the state. It's 680,000 acres, 52,000 miles of shoreline, and then that encompasses 16 counties, 45 municipalities, and Baltimore City. So those are all of the different local programs that are administered with the state law, with the state critical area law and regulations. Each of those jurisdictions implements it through their own planning and zoning schemes. So there are 3 land designations within the critical area: resource conservation area, limited development area, and intensely developed area. They are basically how they sound. The intensely developed area is an area that has more residential, commercial, industrial uses. The resource conservation area is nature-dominated environments such as wetlands, agriculture, forestry, and then the limited development area is in between. It's sort of your traditional suburbs. This is a picture, it's hard to see, but this is a picture of what the St. Mary's County critical area looks like. The green is resource conservation area, yellow is limited development area, and red is the intensely developed area. And the important piece to notice is, again, it's that 1,000-foot wide swath all the way around the water. And within the critical area, there are different habitat protection areas that are subject to different requirements, and one of those is the buffer, right? The 100-foot buffer is the first 100 feet closest to the water, and that is an example of a habitat protection area, and that's subject to even stricter requirements because it is a habitat protection area, and because the functions of the buffer are so important to keeping the water quality of the Chesapeake Bay clean. So what does the buffer do? The buffer removes and reduces sediments and nutrients, it filters runoff, it minimizes the adverse effects of human activities, and basically creates a riparian habitat and creates a separation between the upland development and the aquatic environment. And that's why the laws and the regulations put so much emphasis and importance on the buffer. In the law itself, there are listed 3 goals of the critical area program. I'm not going to read them to you. They're right here on the slide, but it's important to have these as the background for the whole critical area program and the law and the regulations, because they are at odds with one another, right? It's to conserve and to minimize impacts, but at the same time, it's to recognize and accommodate growth. So it's hard to do both of those things, or all 3 of those things at one time, and that's where the tension lies in how to implement the law and the regulations. So now we're moving on to the critical area variances themselves. Before 2008, and I guess some of the changes that came about because of the 2008 changes, what we found was that the boards were basically granting too many variances at the time. There was too much development going on in the buffer. After the fact variances were not treated as a rare exception. They were treated as a solution to a violation. So there were a number of problems that the 2008 revisions attempted to fix. And I'm going to talk about those as we go through some of these standards for the critical area variances themselves. You all know this better than I do, but you see typical critical area variance applications, for example, for tear downs and rebuilds, for accessory structures in the buffer, for grading in the buffer, for exceeding lot coverage. I mean, those are the kind kinds of things that you all see. It's the same thing for the critical area staff. They see those across the state, and they have a statewide perspective on each of those types of different activities and what they entail and what should and shouldn't be allowed under the critical area standards themselves. Next slide, please. Where does your jurisdiction come from? Your jurisdiction comes straight out of the Natural Resources article, that there has to be, as an element of every critical area program, there has to be the authority to grant variances based on the standards under the law. And that has been in the law since the beginning. The General Assembly found it very important to include variances as an alternative to some of the requirements in the law. And I just have on that slide also the regulation for where those procedures are established. Next slide. So I mentioned in the beginning about this presumption. There's a presumption in the law that the variance does not conform with the critical area law and regulations. And I think that's kind of an important, to me, that's one of the most important places to start, just to realize that it's not always a given. It can't automatically be a given to issue every single variance, right? The presumption is actually that we don't issue the variance, that what the person is asking for doesn't conform with the purpose and the intent of the law and the regulations. So what you have to do is find through evidence and testimony whether the applicant overcomes that presumption, right? So there's this presumption that says it doesn't meet the law, and you have to make sure you hear enough evidence and testimony to overcome that and to say, yes, they do meet the law, they are entitled to the variance.
Ma'am, a
Yes.
question.
Yes.
We had an instance a week or so ago, man wanted to build a house on a lot, and we talked about it, and it was granted. But my friend at the end of the table mentioned if we told him he couldn't do it, that made the lot uninhabitable. Basically, it was thrown away. It was his lot, wherever he invested on it, was gone. Basically, the land would have been condemned.
Mm-hmm. And I don't know the details of that case. My question would be whether there was a way to come up with a different configuration to allow a house on the lot, right? I'm not sure if was it a critical area variance?
Oh, yes,
It was?
yes.
Okay.
And it's entirely, in the critical areas down on tidal wetlands, and they pretty much got to build it on stilts. But
Okay.
there was a buildable area, and if we denied it, you're pretty much condemning the property.
And I
built the house on the only possible spot on the
right.
lot.
Right, okay. I mean, then as long as you have heard, I mean, then this comes down to the evidence and the testimony you heard. Did you hear enough to convince all of you that they met the requirements of the law and the regulations? I mean, that's what you have to do in every instance based on the individual circumstances in front of you. I know that the intent of the critical area law was not to take away building rights or development rights from individuals, right? It is not a takings situation. The law recognizes development rights, that certain, that each, sorry, I'm not being very articulate right now, but that each lot has a development right, and that there are abilities to configure things on properties to make sure that they do get access to a reasonable house of a reasonable size and, a house and a garage or something like that. What we're going to talk about and what I'm going to talk about is sort of more of the examples on the extremes, right? The pool in the buffer, or the garage that's unattached to the house that there's no room for anymore, or, things like that. We'll talk about different examples like that as opposed to a house. There's definitely a development right for a house on a lot. Even if the lot is entirely within the critical area, you just then have to connect those standards to the evidence that you're hearing. That would be my advice that's not advice.
Thank you.
Can I
Yes.
I was asleep about 3 slides ago and then finally woke up, okay?
Okay.
So early on, you said critical area was the land underneath the water. Mm-hmm. Okay. Well, if that's the case, we seem to only be talking to critical area to the land above the water.
Right, right.
As opposed to, shall we say, the piers and
Right.
that type of stuff, which I assume is either DNR or some other agency
Yes.
outside this critical area commission, even though it's still labeled critical area.
Right, you're exactly right. So it's sort of, I look at it as concurrent jurisdiction, right? So it is called critical area, but it's up to MDE, it's up to the Maryland Department of the Environment whether to issue a license for a pier on that waterway attached to the land.
But you're still the attorney, and you're just playing one side versus the other, right?
I'm an attorney, right? What do you
Okay.
expect from me?
But it's really not a part of the critical area commission per se.
Correct.
Okay.
Except, I mean, I would say that it allows local jurisdictions to issue building permits for those things over
Okay.
the critical area. Next slide, please. Thank you. So the other important component before we get into the standard itself, we talked about the presumption. The other important component here is that the burden is on the applicant. The burden of proof and the burden of persuasion is on the applicant. The county doesn't have the burden of proof, and the Critical Area Commission doesn't have the burden of proof. You are here to hear the testimony and the evidence from the applicant themselves, and maybe their agents or whoever else that they also bring with them to testify. So that means that you are required to give due regard to the person's experience, technical competence, and specialized knowledge. And that's really what you're looking for. Do you believe them? Do they have the knowledge? Does it make sense? What are they testifying to? So this slide is really for some other jurisdictions. I've given this talk in a couple of other jurisdictions that I admit to you are using the wrong standards. You guys are using the right standards, so we can just ignore this slide. But our state law standards apply regardless of what's in the local program. I noticed that St. Mary's County has an additional requirement that I think it's that the minimization, you have to find that it's the minimum necessary. That doesn't come from critical area law. That comes straight from your own St. Mary's County law. You can skip these 2 slides. All it does is list the variances themselves, and I gave you a piece of paper, an extra piece of paper, which has the standards straight from COMAR, if you want to ever refer to that, if you need something to fall asleep to at night. So a couple of quotes from a few cases. The need for the critical area variance must be substantial and urgent and not merely for the convenience of the applicant. And as a general rule, variances are granted sparingly and under exceptional circumstances, right? So this goes back to the idea that there's this presumption against them and that you have to hear enough evidence and testimony to convince yourselves that they have met the standards in the law, and that it's not merely for convenience, right? If you're not going to give out a variance to somebody just because it's more convenient for them to have to have a patio on the front of their house when they could just as easily have it on the back of their house, for example. That's what these quotes are getting to. So the first standard is, we refer to it as the unwarranted hardship standard. And what this says is that due to special features of the site or special conditions or circumstances peculiar to the applicant's land or structure, a literal enforcement of the local critical area program would result in an unwarranted hardship to the applicant. So it's quite a mouthful. And a lot of cases, in our opinion, turn on this unwarranted hardship standard. Unwarranted hardship, that phrase is defined in the law and regulations, and that's what's in bold there. Without the variance, the applicant would be denied reasonable and significant use of the entire parcel or lot. So what you need to look at here, you need to analyze the entire lot, not just for example, the area where they're proposing to put a garage or something like that, the area where they're proposing to put the patio. No, you're going to look at the entire, sorry about that. You're going to look at the entire lot and determine whether they have a patio. Should I stop talking?
Amy hadn't come in here yet, so
So just
you
keep
should be
going.
doing okay.
Okay, great. Thank you. So you need to look at the entire lot or parcel. You need to look at whether they already have patios, whether they already have accessory structures, whether they already have reasonable use of their lot or parcel. What is reasonable use? Reasonable use generally means a house, a garage, and a small patio. Reasonable use doesn't extend to a pool in the buffer, for example.
Amy, you want to, Ms. Delahaye, your iPad was allowed into the room. Is it possible you can mute that?
Yeah, I'm trying to turn it off.
Thank you.
Yes.
There. Oh. Sorry.
I think you got it.
Okay. Ma'am, a
right,
question.
we're good. Yes.
With the noise, I may not have heard correctly, but if a person has a lot and they have a house, and you're talking about a garage, should we suggest they move the garage somewhere else?
I mean, I think I think a lot of it is what you need to know is what happened before they got here. Have they tried other configurations? Have they worked to minimize it as much as possible? Is there another place for them to put it, but they couldn't put it there because of steep slopes? They couldn't put it there because of a wetland, You have to, they have to design to the site. So if this is the only place for them to put it, then, that's the decision for you to make. If there's a place where they can put it outside of the buffer, that's going to be the comment that you're going to hear from the Critical Area Commission is, don't put it in the buffer, put it outside of the buffer. We're not going to be opposed to having a garage. We're maybe going to be, we might have a comment about, for example, a 6-car garage when you only need a 2 or 3 car garage, right? It's all very, very, very site specific and case specific.
We all come from different backgrounds. And I just wonder if we should suggest or tell them, put it on the other side of the driveway. Should we be doing that?
I think you can ask the question, why did you choose to put the garage here on this side? What prevented you from putting it on the other side? Right?
Okay.
Then you're asking for information. You're trying to understand what the constraints are. I'm not suggesting that you tell them what to do one way or the other. I think you can elicit more information, and that helps you decide whether they have minimized to the extent possible and whether they are designing to the site constraints and things like that.
I recall a case we had years ago when a person wanted a deck, and somebody from the county said, "You don't need a deck that big." I go, "What? You don't need they didn't know if they had 4 grandchildren or 2 sons or just a man and his wife. But for somebody from the county or the state to say, "You don't need a deck that big," I just ruffled my skin when I heard that.
I mean, I think to me, what I would suggest is asking, what is the purpose? What is the purpose of your project? What is the need for the deck that you have? Why are you putting it here? Why aren't you putting it, there? I think, again, it's just eliciting as much information as you can to help you make your decision. That's my suggestion.
Well, most decks, of course, would be facing the water and not on
know.
the side of the house.
Right, I know. I hear you.
Excuse is that we want it out of the sun, right, in the evening.
Right,
Put it on the water side.
right.
Yeah, because I have this feeling that it's along Rich's thing, is it's not our purpose, in my mind, to design
Exactly. Thank you.
what's going on. That's between them, their architect, and negotiating with Mr. Knight and the Luggum community here.
Yeah, I agree with that. I hope I'm not coming across as telling you to tell them where to put something. I don't mean to be doing that at all. What I'm trying to say is I just encourage you to ask questions about what why they've chosen the specific design that they have. Have they chosen a design that is the most minimization possible?
And to follow on, and maybe I'm bringing in a neighbor's scenario, if you have a house that's essentially clearly within the 100-foot itself of the bank, and you wanted to put a garage or anything like this on, I mean, the excuse now is you can say that people have aged up and they want it near the house. But in the past, right behind it is essentially farmland, all part of the same lot. Well, certainly you all wouldn't be looking at it as, oh, the garage really needs to be 1,000 feet back up the road.
No, we would not be telling you that it had to be completely out of the critical
A
area.
normal, shall we say, commute between the garage and the house.
Right. I mean, I have seen in other, probably not here, other jurisdictions, maybe somebody wanted a detached garage. And again, raising the question, why did you choose a detached garage? Does it make more sense to have an attached garage, which takes up, less space, less impacts to the land, is closer to the house, things like that, right? Just asking these questions about why certain decisions were chosen given the site constraints. So what are the specific site constraints that an applicant is up against?
Thank you.
Yeah, you're welcome.
And I, for one, appreciate the recommendations you make in your letter.
Oh,
It helps.
okay. That's great to know. Thank you.
Since you brought that subject up, I'll jump in at this
Sure.
time, otherwise I'll forget it, okay? But when you do object to something, some letters, I'm talking about over my 9 years here, I've seen, some letters just say it's almost like I don't like it, as opposed to quoting what it is that the boundary that's being exceeded, okay? And that's what, in my mind, always needs to be in a letter, especially when you're objecting to something, is what is it that's,
What's the problem? Right.
what's the problem? And please define that to us so we know what it is, okay?
Right.
Just rather than I don't like it kind of scenario.
Right. I think you've seen this.
No, I'm not talking about current letters. I'm talking about, I've seen it over 9
Over-
years where it's gone from,
Yeah.
soup to nuts.
I think there have been changes, probably. Kate, do you want to talk to this a little bit more, or should I? Okay. Okay, there have been changes, I think, to the way letters are presented to boards of appeals. I think there's obviously letters that are full oppositions. Those are the ones that are pages long, that go through every standard.
Yes, I
that-
remember one.
Right, those are the ones where it's like, this is really bad, okay? We really object to this. And then there are letters that are kind of, maybe what you're saying is, we don't like this. These are letters where there might not be it might not clearly be in violation of the law, but it depends on the information and the evidence and the testimony that you get and how you can tie those two things together, tie the law to the facts. But based on the facts that the commission staff gets from the applications, they're making their best estimate of whether it's something that we should come out very strongly against or just a little bit against. And then, of course, there's ones where they have no comment whatsoever, and you might not even see those because those tend to be just an email. So there is a range. And since I'm the lawyer part of this, the lawyer for the commission, the ones that have the full opposition letters, the pages long letters where they go through every standard, those are the ones that we think about participating in if they were to get to circuit court or to the Court of Special Appeals, right? Those are the ones where we want to make sure that the law is applied consistently, not only here in the county, but that the law is applied consistently across the jurisdictions. So that's where That's where a lot of those letters come from. And hopefully in those letters, where they do go through every standard, hopefully there is enough detail that there's an explanation of each standard and why a particular proposal doesn't meet it. And in those cases, those are also the ones we consider participating in now, either virtually or in person, and actually providing testimony to the board to help explain that position. Okay, does that help a little bit?
I guess at what point do you talk to you get the paperwork, questions and everything you have, at what point do you quote unquote pick up the phone or send emails? Because I've never really seen any documentation of any interaction other than evaluating what is presented to you in paper, got sent up the road to you. Is that all you do, or do you, in cases, actually pick up the phone or send emails back and forth getting clarification?
Yes, the commission staff definitely picks up the phone and sends emails to county staff. So
Okay.
there is a lot of interaction between commission staff and county staff. And I will say commission staff, because they are presenting a comment letter, they don't reach out to the applicant, right? That applicant relationship is really with county staff.
Okay.
And the Critical Area Commission advises the county staff of what, right, Harry and Bill.
Harry and Bill.
Yep.
Yeah, Mr. Brown, it's not unusual, because we have a standard transmittal that the Critical Area Commission requires us to fill out, and we send the site plan. So it's not unusual for the Critical Area Commission staff to have questions, and we will research and provide answers to those questions. It could be old permits, when was the house constructed, or even sometimes we use the GIS to try to flesh out what wasn't obvious on the site plan. So there is a lot of interaction between their staff and our staff long before we even accept an application for a variance.
But my question then is, particularly the written documentation that you're exchanging, because I don't think I've ever seen it as a matter of the record that was provided to us. And I'm thinking that if we were to turn it down and it goes to the courts, wouldn't they be looking for every last straw that was based on that decision?
Well, it certainly is public information, but because it's more preliminary planning on the final submittal with the variance application, I don't include it in the package to you. I will remind the board, it's been over a year, but you did have a case with a rather large house
With a lot of
that
rocks?
had an unusual configuration. So it just wasn't your average house. And the board asked, can't you shorten it up 10 feet? And they tried to give an explanation of why there was some architectural importance. And yet the architect wasn't here that day, nor did they have more detailed floor plans. So they asked for a continuance,
And then they dropped the case.
and then they never came back.
The white case.
Yeah, but so there's an example where your board saw an opportunity to suggest that they were asking too much, and there was leeway to adjust the request. Typically, we do so much negotiation with the applicants in advance that it is important that you scrutinize it and look for any additional leeway that we overlooked. But that's why you're not seeing many negative letters from the Critical Area Commission in the variance hearings that are brought before you, because when it's that obvious it's not a winning case, we work with the applicant to avoid bringing a losing case to you.
Right, you can't prove the negative, right? You don't see the cases that they have been able to minimize and avoid the variance for, so, yeah. So the last thing I'll say on unwarranted hardship is, again, just asking questions about why is the site peculiar? Why is the site different? What are the special conditions and the special features of the specific site that makes it so that the applicant needs to propose their specific project in that specific place. You shouldn't consider the landowner's convenience, right? Just because it's easier to have it in here, A versus B. And also, of course, you shouldn't consider that the owner didn't know the regulations or didn't know that the buffer existed on his property, right? The ignorance, what's the saying? Ignorance of the law.
No excuse.
No excuse. Thank you. I was like, I knew there was another part of that.
There's one that's missing there that tends to play out a lot is, well, my neighbors have it.
We're going to get to that one. Don't worry.
Okay.
Don't you worry. We were going to get to that one. Okay, so just an example of where the unwarranted hardship was found for this standard. The case is called Assateague Coastal Trust versus Schwalbach, and what it did was it specified how you have to analyze unwarranted hardship, and that's what the bold and the underlined is. That the applicant would be denied a use of the property that is both significant and reasonable. So when you are asking questions to the applicant and making that determination, why is this a significant use? Why is this a reasonable use? You need to find both of those when you are deciding to find that there's an unwarranted hardship. And this case involved a pier, and the court decided that there was substantial evidence to support the board's finding that Mr. Schwalbach would have suffered an unwarranted hardship and that he would not have been able to exercise his riparian rights associated with the property. And that was a reasonable and significant use that couldn't be done elsewhere on the property, right? So he wanted a pier, and there was nowhere, and the board found through their evidence that there was nowhere else to put that pier, and that the riparian right was a reasonable and significant use of the property. So I think going back to your question about the house, a house is a reasonable and significant use of the property. And so I think that is how you can tie the evidence to this specific standard. Next slide, please. So this is just an example of where the unwarranted hardship wasn't found. The applicant wanted to build an attached screen porch in the buffer, which would also disturb steep slopes. And the court found that he had failed to demonstrate that denial would result in an unwarranted hardship. And that was because it was a less awkward spot is not a sufficient reason to justify the granting of the variance. So my only point in bringing this case up is that it really has to do with each site, each applicant, each proposal. That's why you have the expertise and the experience in order to evaluate each of these circumstances separately in each case. Next slide. Oh, just one more example of where the unwarranted hardship wasn't found. In this example, the applicant wanted to build a one-car detached garage after they had already built their house. So here the court basically said, well, you built your house and you asked for a garage at that point. You could have had a garage when you went to build your house, but you didn't. You chose not to, and now you're coming back later to try to get a garage. And the court there said that the mere convenience of having a garage is insufficient to establish unwarranted hardship. So again, they just couldn't meet that reasonable and significant use of the property, of the whole lot or parcel.
Even though that additional garage is less money. I mean, let's face it, when you build a house, you're building to your max of your financial. So, I mean, I'm sitting there thinking, wait a minute, if it's that was a financial, could have been a financial question.
Yes.
As opposed to preference question.
Right, that's true. So ask, again, my suggestion is to ask that question, elicit that testimony from the applicant. Would your house be worth more with a garage? What?
Or they didn't have the money to lay it out when they get
then.
the initial mortgage, okay?
The next standard has to do with depriving the applicant of a use of land or structure permitted to others in accordance with the provisions of the local critical area program. So this is the one where we talk about neighbors. You might hear often that my neighbor has a blank that big, and therefore I want a blank that big, whether it's pool, patio, gazebo, pick the thing, whatever the thing is. And that is not, under the law and under the regulations, that is not the appropriate standard. You can't compare within the neighborhood. You can't compare unless that house was also developed under the critical area program. So what I mean is you have to compare oranges to oranges, apples to apples. You can't compare a house that should be built in compliance with the critical area program to a house that might have been grandfathered, right? Perhaps they had a pool there before the critical area law came into play. So the neighbor saying, but my neighbor has a pool. Well, but your neighbor didn't get the pool as a result of a variance to the critical area program. Your neighbor got the pool because he had the pool from the very beginning. So that's where we get into this neighbor situation. And that's the questions that I personally would encourage you to focus on when people say, but my neighbor has that thing that I want. Well, was your neighbor's house built in conformance with the critical area program? Is it a violation? For all we know, it's a violation that they put up a patio when they weren't supposed to. They didn't get permits for it. So we can't sort of proliferate all of these accessory structures when they weren't all built in conformance with the program. Does that answer your question about neighbors?
Well, but going along that line, it sounds like if you didn't challenge the neighbor who either did it under the table or, in the middle of winter or whatever he did to do this, i.e. he didn't come down to lug them, and it existed there for 5, 10, 15 years. Now, at what point because normally if you didn't challenge it then, you've kind of opened the door for future reference. In other words, you got to challenge at the time of the infraction.
On the violation side.
On the violation
Yes.
side, so why can't the neighbor then say, hey, it looks like it's legit, okay? Regardless of whether it was legit or not.
Right, and I think the difference is here, in the variance case, it's up to the applicant who has the burden of proof and the burden of persuasion. So that burden of proof includes, they have to show, at least in my opinion, they have to show that that the neighbor got that pool, patio, whatever it was, in conformance with the program. Not just that my neighbor has it. The applicant has to, that's on the applicant. That's their job.
That suggests that they went through the typical permitting process or application process.
Well,
But
they
if they
have
had
to
just
find that
done
out.
it and then the county, the state, nobody reported it for 5 or 10 years, seems to me that's become a fixture to the property and all they're documenting is that was done 10 years ago, period, right?
I mean, again, it's
whatever.
what is enough, and that's your job. What is enough for you to be satisfied that was built in conformance with the critical area program? That is your standard. It's not, looking at LDA lands compared to other LDA lands. It's, was this built in conformance with the critical area program?
Okay. I'll let the dog lie. I mean,
Okay.
we could argue that forever.
I know, we could keep going, right? Next slide, please. The next standard has to do with, would not confer upon the applicant any special privilege that would be denied by the local critical area program. Again, under the local critical area program. So it's the same language where, would it be a special privilege? Is it something that would be unique and that another person wouldn't be allowed to have under the critical area program? So a typical example of this would be a pool in the buffer, right? Generally, the critical area commission staff opposes strongly pools in the buffer. So that would be, at least from the critical area commission side, that would be something that we would consider a special privilege, and you are not allowed to have a special privilege in order to meet this particular standard. I think here you probably hear a lot of applicants talk about how much they love the Bay, how much they do for the Bay, things like that, and those are all fine and good, but they don't go to the actual standard of a special privilege. variance is not related to actions by the applicant. I have a separate slide dealing with after-the-fact variances, so the only thing I would like to say about this one is that you are required to consider it. You are required to consider whether a hardship is self-created. So did this person build something without permit? Was it that person, was it the applicant who did the self-created hardship? Or are they trying to say it's not a self-created hardship if I have a buffer on my property, right? I'm sorry, that's just not a self-created hardship. But it is a self-created hardship when you build something without permits. So there's a process in the law for how to deal with after-the-fact variances, but all this standard says is that you shall consider whether it's a self-created hardship. Next slide.
We had a case recently similar to that, where when I read it, before I got here, I said, oh, no, this ain't happening. And what they had done is they'd reconfigured the boundary lines. Mm-hmm. And they essentially caused the problem. Mm-hmm. But, and I could be wrong, go hide. But what essentially they were doing, they were conveying something to their kids. Uh-huh. And it kind of changed the way you would normally, but if it was, so.
Yeah, I mean, I think, okay, they proved it, right. So maybe in a different circumstance, they couldn't prove it. And you would say that was not, or that was a self-created hardship, and then therefore you don't meet the critical area variance standards.
We didn't get confused by facts. No, or we did, one or the other.
A variance can't be related to off-site conditions. This one really, I have never really seen this one come up, but the idea is that it shouldn't relate to conditions on a neighboring property. And it also shouldn't be associated with removal, right? So a lot of people say, or you might hear, that the impacts of removing something are too great, and so we shouldn't remove it. And that is never going to be the case. Removing something is going to be a temporary impact. So if something needs to be removed, it should be removed. But this one, I think, hardly ever comes up as an issue. So. Next slide, adverse impacts to water quality and habitat. And for this variance standard, you have to find that the variance would not adversely affect water quality or adversely impact fish, wildlife, or plant habitat within the local critical area. And here, I hope there is enough information in the Critical Area Commission's letters on this standard, because usually especially in the full opposition letters, they will describe what the increased sedimentation will do to water quality, and that each impact is individual, but putting those all together, there's a cumulative impact and negative water quality impacts to the Chesapeake Bay. So hopefully, you get enough information from those letters. And I think here another thing that's important to remember is that there has to be mitigation for certain variances. And so here the mitigation is an important component to consider as well. And then the last one
I have a
is,
question.
oh, yes.
Sorry about that.
Guy Bradley, yeah.
Yeah, so the question with that last statement, the property owner gets into the position where damage is going to occur to their property unless they impact water quality or habitat. How do we deal with that? Well,
Say
if
it
they
one
come
more
in
time.
asking for a variance to do an improvement, but that is going to damage habitat.
Yes, okay, I see where you're coming from. And what you need to determine is whether the mitigation is enough to offset that impact, right? Whether they are providing the applicable or, the required mitigation, and whether those impacts can be offset by the mitigation. Does that help?
On the subject of mitigation, we had a case a week or so ago a man lived close to the water, and storms, whatever, the water come close to his house. He decided to raise his house. Considerable amount of money. And to do that, they had to dig around his flower beds, and because he had to move the mulch he put in, and he had to move his azalea plants out, I asked the question, is this really mitigation? And the answer I was given, oh, yes, he's got to plant some more trees. But it was his mulch and his azalea plants he's moved out, and he's going to move them right back as soon as they raise the house. Isn't that really stretching the rules on mitigation?
I don't know. I'm going to have to defer to Kate and Annie behind me on the details of what is a sufficient mitigation.
They're looking at one another.
Well, I would answer because I know the case.
I mean,
So-
Okay, I don't know the case.
Because there's
Thank you.
mitigation for different reasons, right?
Right.
We have mitigation one-to-one for canopy removal, which was not the case. There was no canopy being removed. We have mitigation at 3-to-1 for permanent disturbance, which was not the case because this was temporary disturbance around the perimeter of the house to elevate it out of the floodplain. So this was the required 1-to-1 mitigation for temporary disturbance.
Got it. Okay.
See,
And I think there should never have been mitigation for a man moving the mulch out, raising a house and moving the mulch and azalea plants back. To me, that's just ridiculous.
Got it. Okay.
So if we asked if the board was convinced that we should not approve the mitigation, what would your office do?
Oh, okay.
yeah, you're the king.
Right. Hypothetically speaking, hypothetically speaking, we would probably evaluate whether to take that case to circuit court because because the critical area regulations are not being followed appropriately, right? If you're not providing the 1-to-1 mitigation, then there isn't an offset for those water quality impacts. But I would have to know the details a little bit better, so.
Well, that's pretty much what the details are.
Okay.
He wanted to raise his house, they had to move his mulch and his
Okay.
azalea plants 10 feet away. They raised the house. He's going to put the same mulch and the same azalea plant back. And the answer was mitigation is required. And I don't care if it's 3-to-1 or 1-to-1. It's silly.
But Mr. Richardson, you're not being asked to approve the mitigation. You're being asked to determine that the mitigation is enough. And you cannot seek a variance from mitigation.
Right.
And because we're not asking the board to approve the mitigation, we're asking the board to determine it's enough. We're asking the board to approve the disturbance in the buffer. So the board could say the variance is approved, and the board could stick their neck out and say, and we don't want to require mitigation. I can tell you that as this county employee, I'm going to administer the mitigation requirements of the ordinance.
I can't hear. I've lost a battery in my hearing aid. Would you say it one more time?
That I would feel obligated as a county employee to administer the appropriate mitigation requirements of the ordinance.
Any other mitigation? I'm scared to ask. Any other mitigation?
Yeah, I have one.
Okay.
It occurred before this is 10 years ago,
Okay.
before I got on the board. It was a piece of property, and of course, it's on the water, of course, being St. Mary's County, in which essentially two brothers had bought a large piece of property as a single parcel. Well, that was back in the 40s. And of course, time came along and different families. And so by the time you got to the third generation, and everybody had built a home, okay, as they thing, you had 4, 5, 10 homes on this property. Well, the logic finally stepped in, so you don't have to have a family conference if you want to sell your house, of let's subdivide this property,
Okay.
okay? So what you're really doing is walking around and driving iron pipes in the ground, delineating everybody's parcel. And that's all you're doing. It's more of an exercise with a pen in a paper as far as the county's concerned. Well, that resulted in, I believe, close to 1,000 trees when it got to mitigation. And somehow it vaporized, but they still took care of the additional trees. But my real question is, why? When in fact you were disturbing, the only thing you were disturbing is when you put that damn iron pipe in the ground, okay? Can somebody kind of explain why that kind of thing, because to the normal layman, it seems like something's wrong here, okay? And I'm doing it for our TV audience as well as anybody that may be on the board, but.
It sounds to me that this is not a variance case.
Please come to the microphone.
Oh, come on up here where we can hear you.
I'm phoning a friend.
When the party.
This makes it legal.
Let's make associated with a new subdivision as opposed to a variance case?
So you were taking an existing piece of, and you were subdividing it only so that individual members of
Right.
the family had their
Right.
title to their own property, okay?
Right.
You really weren't doing it for speculation or anything
Right.
else.
Right. So in 2010, the commission amended its regulations, which lay out all of the requirements that then the county incorporates into its code and implements. And as part of that, the commission made it very specific about when a subdivision that includes buffer is approved, that if the buffer is not planted or vegetated, that the buffer would be established in vegetation. And the purpose the commission had in making that very specific regulation was that it was always the intent of the original criteria from 1985 that as we saw properties be developed, as we saw subdivisions be approved, oftentimes on agricultural properties, and houses would be put up, that there would be forested buffers created to help provide that water quality and habitat benefit to offset the impacts of the development. So how, a intrafamily transfer subdivision, that may already be developed, it would really be based, that can be a special provision incorporated into the county code. But if that provision is not somehow incorporated into the county code to address special instances, then the county is implementing the regulations as they are in COMAR, which requires this consistent application of subdivisions should include
Altered to
buffer
the state.
establishment. And the commission is, the commission is 28 members. It represents all of the county's diverse interests, and, they were a clear and specific part of drafting those regulations.
Do they still meet monthly?
They do. We do, online, hopefully soon in person. But yes, we've been meeting virtually the first Wednesday of every month.
And Mr. Brown, while you aptly described that driving surveyor stakes in the ground and drawing lines on paper does no soil disturbance, a true statement, it is still by definition development activity. And the development activity triggers the need for the mitigation, in essence, to pre-improve the land for that future development. Now that it's a buildable lot, that the anticipation is the future development will come.
But they didn't leave any blank property, it was a large piece of property, and later on, it may have been a second home on another piece of property, so.
Yeah.
It's when you're dealing with family, okay? And I know you know who I'm talking about, but
Okay.
enough said. It was one that when I first got on this board, it was like, I'm gonna fight that, and then it became a standard. He's taken over, but every case that's presented, what is it? Why do we have mitigation? Can you please explain? I mean, right over there, they know it's part of their verbiage. They have to explain it to us. But I mean, it kind of galls at least this member of the board
And this one.
that in some cases, why? Okay?
Yeah,
You're
'cause it
really
was-
not disturbing.
It was not a development, it was just a family son built a house, the daughter built a house, another son built a house, all family, and mitigation for that, and I know which one he's talking about, is crazy. Moving right along.
Can I ask
All
a
right.
question?
Yes?
It's not about mitigation.
This is Lindella.
On your slide there, that no adverse impacts on water quality and habitat. If a person's land is being washed due to erosion from the water,
Right?
can they, and they are going to disturb the habitat because there's, water grasses there in front. Will they be able to build a seawall there or put riprap down or whatever?
That would be a question for the Maryland Department of the Environment. They would be the regulatory agency who would approve whatever improvement would be allowed. The law specifies that the hierarchy, the first choice is for a living shoreline, but if you can get a waiver from a living shoreline, then they would be able to build something involving riprap or a bulkhead. Probably not a bulkhead, but riprap.
But isn't a landowner supposed to be able to save their land?
Yes, there's a statutory right to protect your shoreline from erosion, but then there is also a law that requires the first option to be a living shoreline. So you have to use both of those laws together.
And I can tell you from experience, we see a lot of revetments in St. Mary's County, so they must qualify for those waivers quite often. And you don't see revetments come before the board for disturbance in the buffer because they're a unique class of improvement. I don't even want to use the word development because we're trying to avoid the erosion. And so, shoreline protection projects are exempt from the buffer development standards that come before your board.
Okay. All right, thank you.
You're welcome. Okay, last criteria is harmony with the spirit and intent of the critical area program. So this is kind of a wishy-washy one, and so my recommendation here is to go back to the goals of the law that I had mentioned at the beginning. Does it foster more sensitive development activity? Does it help restore water quality and productivity? Does it avoid impacts to water quality? And does it avoid the buffer? Can the variance be avoided at all? Is there a way to reconfigure it to be better suited to the site? And again, mitigation should be addressed. So the last thing I would say on the critical area variance standards, and I'm sure you guys all know this at this point, but you have to find every single one of them. Without one, you cannot grant the variance. So you have to have an affirmative decision that the proposal meets every single standard. Next slide. So what is the commission's role? I talked about it briefly in the beginning, and I will just touch upon it again here. They review and comment based on the information that's submitted. They can do site visits as appropriate. They can testify at Board of Appeals hearings. But overall, they have a statewide perspective and they provide consistent guidance in the application of these standards. Next slide.
Wait, whoa, back up.
Oh, sure.
This is one of my things I beat on all the time, site visit as appropriate. Do you actually come down here and visit sites? Do you put that in your letter?
It depends on, and I will say, it's just really case specific. It's not frequent that we do it. I mean, there's a lot that can be seen, GIS resources. We have 7 critical area planners that work with 64 local jurisdictions. So some of the time it's just dependent upon, their caseload. But if we were to visit a site, we will make sure that they note it in the letters.
Thank you.
Okay, so after the fact variances, all I wanted to point out for this slide is that there is a special process and procedure in the law and regulations that you are required, not you, but the county is required to follow before you are allowed to hear an after the fact variance. So the requirements are up on the slide and I will not read them to you. Next slide. So what is the ideal situation? The ideal for us, for the Critical Area Commission, I think your job is incredibly hard to try to evaluate these cases and hear the testimony and hear the evidence. So from my perspective, the ideal situation is that your decisions are based on an accurate site plan, that you talk about the overall lot conditions, you talk about the special features of the site, and that the decisions have addressed every single standard, that you discuss the evidence and how that evidence ties to the standard, and that you say that you've made the determination that the applicant has met the burden of proof and persuasion. Next slide. And then, yeah.
Along these lines, at least I'm back again, I'll ask the question now, but I'll forget it later. You see or get copies of our decisions.
Yes.
Do you have any recommendations of things that you see that really should be put in our orders that may be missing? Because in my 9 years, the orders have gone from really very limited to very detailed.
Yes.
Okay? Of course, I realize we've had a couple court cases, and one of them I think we learned a lot from, even though it subsequently went away. But I just didn't know if you all, throwing the ball back at you,
Right.
see stuff that should be in the orders that maybe they aren't, okay?
I thank you for asking that question. Most boards don't ask me that question, so I appreciate that. What I have reviewed from the recent decisions, I think your decisions are much better than many other boards. I think I really like the way that they are formatted. I really like how clear they are. I really like how much you list out the exhibits and the evidence and the testimony that you hear. My suggestion, I am not giving you legal advice, but my suggestion is to try to get a little bit more specific where you discuss each standard. Just get a little bit more specific about tying the evidence to the standards, especially for unwarranted hardship. That's the one where, to me, I think there is some room there to make it match up with the standard a little bit better, right? To talk about the reasonable and significant use of the property. That's really the key for that one. Not just that wherever they put this, they would need a variance. It's really what is the use that they're putting it towards and how does the standard meet that? So that's really, for me, that's the biggest one that I would suggest needs a little bit more.
Well, I've always been taught if you can't stand the answer, don't ask the question. But since I'm leaving, I guess I asked the question, okay? And the gentleman over there is excellent. He's written one while I've been here, well, several, but he wrote one recently, it was excellent in my mind.
I think they're very good. Yeah.
The county attorney writes most of them.
Most of them.
Assistant county attorney, and I've written one since I've represented the board, and he can't stop complimenting it. I don't know what I did. I have no idea.
But it wasn't a critical area, was it?
No, it
either?
wasn't. No.
So I have a question.
Yes.
When it comes to the burden of persuasion, something that, and this could be answered probably by the board members also, since I'm pretty new to this whole thing. If the neighbors come out vehemently against something, they just don't want it, but the package has met the all the criteria legally, how much weight does the community have on, or how much weight should we be giving the opinions of the community vice the legality of the package that the person is presenting?
Mm-hmm. In my opinion, I think you should give them, when they are discussing the standards and they are discussing the site itself, the specifics of the site, the specifics of the proposal, the specifics of the critical area standards, then I think you can give them whatever weight you think they deserve, right? Like, are they are they experts in something? Are they competent? Are they, do they make sense? But if they are talking about how they don't like something, or they don't like the way it looks, or, things, issues, it's going to bring a lot of noise, it'll bring a lot of traffic, issues that are outside of the specific standards that an applicant is required to meet, then I don't think you have to give them any weight.
Okay, just as it seems like, and please other board members chime in on this, it seems like one part of our job is to definitely consider the opinions and attitudes of the people. But I think the vast majority of our job is the legality of each issue. Am I correct?
I'm nodding my head. I'm not sure what they're doing, but
I can't see any people, the Board of Corrections, Appeals, or the camera's blank on this one.
Well, I think it depends upon what the comments from the audience are. They have some legitimate concerns, traffic, or if it's variances, what effect it's going to have on the water. And I think we have to listen to them, but we also have to listen to the professionals that are making the presentation for the applicant, if there are any, and to weigh that evidence as to who we believe is right.
Yeah, I got in hot water on one case that in terms, the person complaining from the public did not provide any specificity in other words, they were just complaining. And I probably should have kept my mouth shut, but I basically pointed that out to them. And of course, subsequent callers, said the board had already had their opinion made. But having sat here this length of time, the more specific, the more data you can give the board, these people don't seem to understand. They just can't walk in and say, I don't like it.
If it's an issue that affects many property owners, it may be their best half is to go out and get some professional engineering assistance or planning assistance to help their case.
Yeah. But you all see it too. I mean, it's the same thing that all boards have.
right.
John, I can't ever imagine getting in trouble for anything you say. That just surprises me.
Who's that for?
That was a
That's
joke,
been
guys.
a guy.
Yeah,
I'll laugh.
I'll
Okay,
have to.
thank you. Somebody laughed.
This is the fellow who will probably be replacing me.
Got it.
Question. I'm sorry.
So I think we've touched on everything on this slide. Yeah, so I won't go into any of those details. What does it mean to have sufficient findings and reasoning to support your conclusions, right? So how do you make your decisions as best as they can possibly be? And this is what I was getting to, that there has to be articulated evidence in support of your conclusions in order to have a meaningful judicial review case. Can a court look at that decision and come to the same conclusion that you did? That's really what the goal of writing these Board of Appeals decisions are. If you just state a conclusion without tying it to any of the evidence that you hear, it's not going to be upheld in circuit court. Next slide. And then finally, the appeal process. The Critical Area Commission has standing to appeal decisions, and we have 30 days to do that. So what we have tended to do recently is if there's a case that we are interested in, if there's a case that we are concerned about, we have tended to participate in it at the Board of Appeals stage in order to provide the testimony that we need, and then see what happens at the circuit court stage. That's kind of our tendency so far. So if you don't see us here, that's probably a good sign. But if you need testimony and you need evidence and you need the commission staff to explain their comment letters, feel free to ask.
How many cases have you had to step in against St. Mary's since this law has been?
Oh, boy.
Yeah, none for me, but
Because I haven't seen it in 9 years.
I remember one from last century.
Well, he's
Really?
been
That
around
far?
that long.
There was
That's
one
20-some years
from,
ago.
like 2007 or 2008. maybe.
Okay, so it's very few that
It's
it's ever,
very few.
where you had to step in, where you all stepped in on the decision of the board.
Or did you appeal the decision to the board?
We appealed the decision of the board
To court.
yes, and it was a complicated case, so I think we lost.
Good.
That must be why I don't remember that one. But the one in the 90s, the Critical Area Commission prevailed.
Okay.
Okay, I'm sorry. Here I am interrupting again.
No, that's cool. Please, I really, really appreciate all the
Because
questions.
it sounds like maybe in some other counties you step in frequently.
Yes, I have, I can tell tall tales, right? I have 2 in Cecil County right now, 2 at the same time, so just as an example.
I could be confused or just forgetful, but Rose Crawley, is that, no? No? I'm trying to think of someone from Critical Area Commission. That's how long ago I've been here. I've been here like 13 years.
Mary Owens?
Oh, yeah, I remember Mary Owens.
Mary, yes, she's no longer with our staff. Yeah, there was never a Rose, but Mary worked down here quite frequently. So,
I just remember a quote, because I've sat through, I think this is my third one. And she said, I thought it was the other lady, but
Mary Ann
could have been
Dice.
Mary Ann Dice.
But she said, the best you'll ever get out of the Critical Area Commission is we do not oppose.
That
That's
is
the best,
correct.
that's the best you're going to get.
That has stayed the same. Yes, our staff, we do not typically write, we support, but
Right.
we will write, we do not oppose.
We do not oppose. And that's the best you're going to get.
It's over.
And I think, is that the end of my slides? Yes, and that's the end of my slides. So do you have any other questions?
Well, I got one other question that may be somewhat related.
Sure.
Each of the Maryland jurisdictions had to reduce its nitrogen and phosphorus levels to certain standards. And I was wondering if perhaps maybe you guys might know what the other counties are doing, how far along they are.
Oh.
MDE question.
It is probably an MDE and DNR, an MDE question in terms of tracking those reductions. It's part of the Phase 2?
Bay restoration
Or
back-
Phase 3 WIPs?
Phase 3 WIPs.
Yes. Yeah, I don't know the answer to that question, but I'm happy to find a contact and pass it along with MDE.
Yeah, email it down, text it down, just to.
Sure thing.
All right, any other questions? Thank you so much for your time and for all of your questions. I really appreciate it. It's been really nice.
Emily, thank you all for coming down.
Yeah, thank you.
Kate, Annie, thank you all for, are you in the county?
Thank you. Thank you very much.
Thank you, guys.
Is Annie in the county? I thought you said that she was a local.
No,
No,
no.
okay,
Shannon is,
okay. Okay.
Up by us.
But anyway, thank you all for coming down. I mean, it's a long drive down. Take your time going back.
We will, thank you.
Make sure you stop at one of the restaurants locally and get a good crab cake or a bowl of cream of crab soup.
And your tail lights are working.
And
Make sure
They are.
They are. We have a different car, so.
there's some brown cars out there that'll let you know that whether they're working.
I know about those.
Okay, thank you.
Thank you.
And thank the board. I mean, that was very good participation.
Yeah, that was a
Questions.
great level of questions. Thank you.